Hare Krishna. Welcome to Tax YouTube channel. This is C. Rohanar, a practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Mars Network. Welcome to the video series on GST disputes, practical aspects, and today we are going to discuss topic litigation strategy. So let's dive into it. Let me allow to share my screen. Yes. So what key learning areas we will going to learn today in this particular session? Gathering and understanding of the facts, legal provisions invoked and involved, advising the client on litigation aspects that need to be considered, read as alternative remedy, then payment under protest, refund matters, checklist at show cause notice stage, drafting reply to show cause notice, and checklist at appeal stage. So let's start with it. Key concern to any organization is to what? Avoid tax disputes, right? But disputes may crop up even after adequate precautions and care being taken. This is also right. So this is due to the lack of clarity and simplicity in the laws. Litigation strategy helps to what? Analyze the various factors. So it helps to arrive at a decision to whether litigate or not. This is also very important decision. Litigation strategy comes into play two times. When a taxpayer takes a tax position and when a taxpayer faces departmental action by the way of inquiry or investigation. Further, let's understand gathering and understanding of the facts. So, very important and crucial step in litigation is what? Gathering and understanding of the facts. So, to have a complete control over your facts, legal representatives must need to what? Understand those facts. Major reason for setback in litigation would be wrong facts or wrong understanding of the facts. Very important. Please note this. As a professional, we should understand this. As a reason for a setback in litigation will be what? Wrong facts or wrong understanding of the facts. So if facts are not properly presented, then there will be what? Risk of losing the credibility of the case in the court and other legal proceeding. So need to differentiate between the facts that are taken for records and that are not taken on record. So inclusion of new facts can be done where notice is what? Silent. However, taxpayer assertion can't be readily admitted unless they are substantiated or corroborated. So even books of accounts not reliable if they are not corroborated. So this also need to be taken care of. So one can include in their facts positions, those are taken under allied laws before other regulators also. So one need to what? Validate the facts relied upon. Management may willingly or unwillingly be restrained to share the complete facts. So, as a professional, we need to tell them or our conversation or a talk like this that they will open us every facts before we going to whether we're before going to hate litigate. So we need to build a trust while we are discussing on any litigation matter with our client, with our prospective client. So that need to be taken care of. So what legal provisions involved and invoked? So legal representatives should understand the legal provisions based on which audit party or investigation asks the assessee to pay additional tax or issued what? Show cause notice. So tax provisions are dynamic and what? Not static. So tax provisions are prone to frequent changes and amendments, you know. So it is important to what? Analyze and understand the legal provisions based on which the show cause notice has been issued to your client. So department may invoke wrong provisions also. Many times it happened. So as a professional legal advisor, we need to know and updated on ourselves that we need to be updated recent recent changes in the law itself. So it is very common for demand to be raised without considering the relevant provision also. So defect in the notice can be fatal one. So adjudication based on the defective notice which are not curable can be held what? Illegal. Notices which are issued and asking for information rather than providing a clear allegation could be contested as invalid. Means unless and until we know all these facts and understanding of the law, we cannot defend our client's case very firmly. So we need to be updated. We need to know the updated law recent changes. So that is what notices which are issued and asking for information rather than providing a clear allegation will be what contested as invalid. So advising the client on a litigation, what needs to be considered? So jurisdiction circular issued by respective state that need to be looked into, validity of the notice and cause to support the demand, merits of the case and whether statutory provisions support that case or not, existence of evidence in support of allegations, interpretation adopted is backed by precedent decisions or not, then impact of losing the case that need to be also be analyzed and also explained to our client, then benefits of accepting the demand that need to be explained, opportunity to avail concessional penalty. Means before explaining to the client we need to understand all these factors. Issues with respect to ITC availability or availment and utilization, and where the client accept the liability and pays it along with interest and penalty benefit of it, impacting on other existing litigations, then impact on tax position adopted under other taxing statutes, impact of tax position taken in East 12 regime and their impact in GST regime. Means that need to be also analyzed. Cost of litigation and up to what level litigation will go up, like up to the tribunal or high court or supreme court. That also need to be analyzed as a professional or a legal advisor, and that need to be explained to our client. Then authority at which litigation may be resolved, presence of grounds to counter fraud. CA is not expected to give and or provide any assurance about the favorable outcome. That please note down this fact. As a legal professional, nothing have been assured that the favorable outcome definitely will come. Of course, our experience, wisdom should trust that process to the client that yes, we are definitely going to favorable outcome from our side, but we can't assure that. So CA can inform about the legal position and the possible outcome to the client. Instead of assuring of any certainty of winning to the client, what CA could explain that what are the key issues involved here, findings reached, then grounds taken in appeal and interpretation. That we need to be explained. Then what would be the alternative? That is a read as an alternative remedy. One need to explore all the alternatives option available along with the replying to the notice on merits, right? At the beginning of that stage only, we need to analyze all the factors. So what alternatives available? When demand has no negative revenue impact, then the taxpayer could either pay taxes under section 73 and take credit, or take grounds of revenue of neutrality and litigate the matter accordingly. So where demand appears to be wrong or beyond the scope of the powers of issuing authority, or if there is a requirement to challenge the legal provisions or rule or notifications or circular, then it is advisable to file what a writ challenging the show cause notice. So writ viable due to what due to adjudicating or appellate authorities can't express their views on validity of the provisions or rule, etc. So that time writ is what a viable option. So what is understanding? Let's understand payment under probation. What is mean by that payment under probation? So whenever issues are debatable, payment under probation could possibly reduce what the burden of interest in the case of future unfavorable outcome. So that is also a key while discussing with the client. So due to this, interest amongst amount gets limited till the date of the payment. So no express provision in GST to make payment under protest, but we can do that also. So no provision for pre-deposit more than the prescribed for filing the appeals. Payment under protest is a what constitutional right, and therefore there may not be a specific provision with respect to this. That is the constitutional right of the particular taxpayer. So let's understand refund matters. Compilation of the relevant documents and submission of such documents, then principle of unjust enrichment and cases where these are not applicable, time limit within which the refund claim should be filed. If duties or taxes are paid under protest, no limitation would apply. So interest on delayed receipt of refund, that also need to be analyzed and explained to the client. Let's understand waiver of the interest and penalty under section 128. If a waiver option need to explore, then following need to be considered. What? Where case has lesser chances of being resolved at a subsequent litigation stage. Cost of further litigation is higher compared with possible benefit in terms of demand relief. These are the five things we need to analyze as a legal advisor. Where demand for interest and penalty with a nil or negligible tax amount. So that aspects need to be analyzed. So let's understand checklist at a show cause notice stage. For the activity of a drafting and a reply to show cause notice, prepare and follow a checklist, right? It ensures what that all the vital aspects are considered and covered and enhance our drafting. So once show cause notice received, do following fast track check. What? Check the date of the service of the notice, useful to context the matters on the limitations. Perform a test of jurisdictions to check whether notice is without jurisdiction or with wrong jurisdiction. Means these are the first things we need to check on. Check whether notice bear incurable defects. So we need to first, the important is the date of the service of the notice to context the matter on limitations, and then the also test of the jurisdiction. Then routine checks and do's. What? Check whether the complete set of show cause notice been served by the department. If necessary document not provided, write it down to the department to make available relied upon document. One, what documents they are relied upon. Obtain proof of the date of the service of the show cause notice, and then obtain complete set of correspondence between the client and the department, whether the client's accounting, the internal department already began the communication. Then understand the facts from the client and obtain what necessary documents. Analyze, understand the facts and issues and quantify wherever necessary. So check powers of the officer to issue the show cause notice. Check whether reply is to be addressed to an officer other than who issued notice. That also need to be considered and checked. Let's see drafting reply to show cause notice. Background. Brief background of the assessee should be given. Then explain the facts, state the background which leads to issue of the show cause notice, and briefly mention what the issue, amount proposed to be demanded. Then reply, your reply should be each of allegation should be addressed. Nothing should be remained not responded. You need to respond every allegation. Provide evidence to support the contention. Then where the facts assumed by the department, provide documentary evidence to support the actual facts. Whenever issue relates to interpretation of the provisions, support the contention by relevant circulars, decisions, and other relevant material. Where penalty is imposed, support the reply with decisions. And your prayer should be the reply should conclude with a prayer like to provide opportunity to explain the case and to drop the proceedings. That is very much important. Let's see checklist at appeal stage. So with supporting evidence, obtain what the copy of the order. Time limit to file an appeal starts from the date of the receipt of the order. So evidence of date of receipt may have to be produced before the appellate forums. So process adverse order read, appeal to be drafted, and statement of the facts. So grounds of appeal will be like order is contrary to the law, contrary to the facts, contrary to the judicial authorities. So belated appeal requires what? Condonation application. For each ground of appeal, prepare what? Sorry for the interruption. Let me allow to share my screen again. So we were at the checklist appeal stage. So Grounds of appeal, like order is contrary to the law, contrary to the facts, contrary to judicial authorities. So belated appeals requires what condonation application. For each ground of appeal, prepare what detailed submissions. Carry synopsis to assist what during your arguments. That is very important. Then other notings, what will the Commissioner of Appeals has limited powers to condone the delay. That also we need to know. Give breakup of your demands, confirm, and demand dropped by the summarizing the order. So advise the client about options available. So following aspects need to be considered once confirmation received from the client. So read and understand the provisions relating to the appeal. Appeal should be filed in a specific form and format. So pre-deposit amount to be calculated and informed to the client well before to avoid any misunderstanding. Don't leave any question in the form unanswered. Prayer for relief should be specific to defend your client. Okay, at the time of the your preparation of the grounds and everything, at the time of preparing your reply. So verification need to be completed and signed by the authorized person. So drafting of appeal memorandum, let's understand that. Brief background of the assessee and issues involved that need to be given. Factual information, chronological events prior to issue of the show cause notice along with relevant documents to be enclosed. Then summarize the allegations in the show cause notice, your reply and findings of the impugned order. So grounds of appeal. State in precise and concise manner, counter the findings of the respondent if he has dealt with the ground. Then findings in order cannot travel beyond the proposals in the show cause notice. If it has made out a new case, then it should be what mentioned in the grounds. Refer GST Appellate Tribunal Procedures Rules 2025. So we need to be updated as a legal advisor. Every law or every update need to be went from our eyes. So copies of appeal memorandum, two set before the Commissioner of Appeals, then four set before appellate tribunal. Appeal memorandum shall be signed and verified and shall be an index. Then one copy of order impugned signed as a true copy, and then the appeal memorandum with the annexure shall be stitched like a booklet. So what is the takeaway from today's session? So litigation is not a formal reply to any notice issued, but what a strategy to evaluate and thoughtfully consider the approach in responding to the tax authorities under the law. Means we need to be first update ourselves before going to defend any case, your client, your prospective client, whatever it may be. First, we need to understand and read the relevant provision of the law. Then we need to analyze. Then we need to go through the facts of the our client. Then we need to analyze those facts, and then we correlate the provisions of the law and the facts. And then we come to the conclusion by doing all these exercise. So please have a prepare for these things and then of course, move ahead with your litigation practice. Thank you so much once again for patient hearing. Stay connected with the Tax Guru YouTube channel. If you are not yet subscribed, then do subscribe for latest updates and video series like this. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.